Thank you, Madam President. It's a great honor to appear again before this court on behalf of the Republic of Armenia. Madam President, members of the court, we have addressed this morning the essential facts underlying Armenia's request for provisional measures and explained why the court's legal standard for issuing such measures has been met. My task is to explain why Armenia's first 9 requests are all necessary to preserve the rights of ethnic Armenians under the CERD, leaving to my colleague, Professor Darjan, to explain why the 10th measure is equally necessary. I will conclude by explaining why issuance of these measures would not require the court to resolve any facts prejudicial to a decision on jurisdiction or on the merits in this case. The members of the court may wish to refer to tab 2 in your judge's folder, where you will find the 10 measures that Armenia requests. The first measure is that Azerbaijan shall refrain from taking any measures which might entail breaches of its obligations under the CERD. This broad measure does not seek to address a specific type of conduct, but it is warranted given the diversity of Azerbaijan's acts since 19 September 2023, which have severely jeopardized the CERD rights of ethnic Armenians. The second measure we request is that Azerbaijan shall refrain from taking any actions aimed at or having the effect of, first, displacing the remaining ethnic Armenians from Nagorno-Karabakh, second, preventing displaced persons from returning to their homes in Nagorno-Karabakh, or third, preventing those who wish to leave Nagorno-Karabakh from doing so. This measure is in essence about the freedom of movement of ethnic Armenians in relation to Nagorno-Karabakh. The court has ordered similar measures in the past, including in the Georgia v. Russia CERD case, where it ordered that the government controlling territory must ensure to the local citizens of that state the right of persons to freedom of movement and residence within the border of the state. As we have noted, Azerbaijan has already taken numerous adverse steps that have promoted the displacement of ethnic Armenians and prevented their return. As Mr. Martin explained, following the 9-month-long blockade that caused a humanitarian crisis in Nagorno-Karabakh, Azerbaijan attacked the enclave, targeting numerous civilian structures, including homes and schools. That attack, combined with the fear of inevitable atrocities that would follow, and with the history of extreme discrimination against ethnic Armenians, forced the displacement of more than 100,000 ethnic Armenians residing in Nagorno-Karabakh at the time of the attack, including more than 30,000 children. Azerbaijan must be ordered to refrain from any such conduct in the future. At the same time, Azerbaijan has not taken meaningful steps to allow any possibility of return. Azerbaijan assures us that it will afford ethnic Armenians in Nagorno-Karabakh all rights and freedoms in line with its constitution and relevant international human rights mechanisms. Yet, in this context, such vague assurances are simply not enough to bring about the necessary conditions for the return of ethnic Armenians, given the long-standing and well-documented hatred towards them, and given the lack of any concrete assurances, such as that civilians will not be prosecuted if they return. that ethnic Armenians will enjoy meaningful political representation, that homes which were destroyed will be rebuilt or repaired, or that those homes remaining intact will not be reassigned to Azerbaijanis. Moreover, a promise of reintegration does not respect Nagorno-Karabakh's unique historic status, including as an autonomous oblast within the Soviet Union. To the contrary, President Aliyev has promised that, and I quote, Armenians living in Karabakh will have no status, no independence, and no special privilege, end of quote. Azerbaijan's vague assurances and unhelpful promises also ring hollow in the face of Azerbaijan's continuing conduct on the ground, such as threatening Armenian cultural heritage in areas newly under Azerbaijan's control. In short, Azerbaijan also must be ordered to refrain from actions that prevent the safe and expeditious return of those who have been displaced. And of course, future steps by Azerbaijan must also allow any ethnic Armenians in Nagorno-Karabakh to leave if they are able and willing to do so. The third measure we request is that Azerbaijan shall withdraw all military and law enforcement personnel from all civilian establishments in Nagorno-Karabakh occupied as a result of its armed attack on 19 September 2023. The court will note that we are only requesting that Azerbaijan military and law enforcement personnel withdraw from civilian establishments that they have now occupied in Nagorno-Karabakh, meaning withdraw from establishments that are not military or that are not law enforcement installations. This request is intimately related to the circumstances that led to the massive displacement of ethnic Armenians and any possibility for their return. Unless such personnel are withdrawn from civilian establishments of Nagorno-Karabakh to include its residential communities, civic buildings, schools, medical facilities, and places of worship, ethnic Armenian civilians, all too familiar with the past atrocities committed by Azerbaijani government personnel, will continue to feel afraid of living in or returning to Nagorno-Karabakh. Indeed, reports and videos have now emerged of Azerbaijani personnel shooting at civilian homes, ransacking those homes, and looting private belongings. These being the same military personnel previously seen on video and in photographs beheading, torturing, and otherwise abusing ethnic Armenians. And sadly, these are the same military personnel that instead of being prosecuted by Azerbaijan are rewarded and their acts glorified. The fourth measure we request is that Azerbaijan refrain from impeding the access of the United Nations to the ethnic Armenians of Nagorno-Karabakh, or otherwise interfering in UN activities. The only way to guarantee that ethnic Armenians will feel safe in returning to and remaining in Nagorno-Karabakh is for a UN monitoring mission to be granted ongoing, unfettered, and unimpeded access to the entirety of the region and to the ethnic Armenian community found there. Moreover, such a mission should include representatives from UNESCO, which Azerbaijan has previously blocked from visiting Armenian cultural sites. In fact, as you have heard, a proposal for such a UN monitoring mission has received wide support from the international community over the past 2 weeks. But as Ms. McDonald has explained, Azerbaijan has failed to commit to it. Azerbaijan this afternoon will surely make much of its consent since the September attack to a very limited and very brief access to Nagorno-Karabakh by a few UN personnel. But as Mr. Martin noted, a limited scope, one-day visit is not the type of UN mission that the international community insists is required. To ensure full protection of the rights of ethnic Armenians under the CERD, what is needed is an ongoing and unhindered UN mission, one that is staffed with human rights experts, and that is allowed full transparency as to what is happening in the region. The fifth measure that we request is that Azerbaijan likewise refrain from taking any steps that impede humanitarian assistance by the ICRC to ethnic Armenians in Nagorno-Karabakh, and instead that Azerbaijan actively cooperate with the ICRC to that end. As Ms. McDonald indicated, the ICRC plays a pivotal role in 3 key areas. First, ensuring that the few ethnic Armenians remaining in Nagorno-Karabakh are located, provided for, and if needed, transported to Armenia for safety. Second, the ICRC is critical for finding persons and retrieving the remains of deceased individuals. And third, the ICRC is essential for visiting detained Armenians in Azerbaijan, which thus far it has not been permitted to do. Indeed, Azerbaijan has a demonstrated practice of impeding the work of the ICRC, including during the aftermath of the 2020 war, when it hindered ICRC's access to detained civilians and POWs, and more recently when it impeded the ICRC from transporting humanitarian aid to Nagorno-Karabakh. Azerbaijan even kidnapped ethnic Armenians who were being transported by the ICRC to Armenia during the blockade. Given this history, while there is some evidence of limited ICRC access to Nagorno-Karabakh today, an unequivocal measure from the court on this issue is essential. The sixth measure that we request is that Azerbaijan immediately restore public utilities to Nagorno-Karabakh and refrain from disrupting them in the future. As Mr. Martin noted, the ethnic Armenians of Nagorno-Karabakh were exposed to darkness and frigid temperatures for months as Azerbaijan interrupted and at times completely suspended the provision of gas and electricity to Armenia, from Armenia to the region. While supply of both gas and electricity to the region has begun to be restored, the electricity and the gas pipelines are now supplied from Azerbaijan and not from Armenia. Thus, Azerbaijan now has complete control over the provision of these public utilities to Nagorno-Karabakh, and yet there is nothing to assure ethnic Armenians that Azerbaijan will not once again arbitrarily cut them off. Consequently, this measure is also critical. The seventh measure we request is that Azerbaijan refrain from taking punitive actions against the current or former political representatives of Nagorno-Karabakh, as well as its military personnel. By not taking punitive actions, Armenia means that actions that seek to punish such individuals simply because they sought to represent and protect the ethnic Armenians of Nagorno-Karabakh must be prescribed. We mean you cannot take actions to punish them through the denial of CERD protected rights, including the rights under Article 5b discussed by Professor Sicilianos. As we have explained, Azerbaijan has already detained at least 8 high-ranking current and former leaders of Nagorno-Karabakh, and Armenia has reason to believe that Azerbaijan has detained an unspecified number of others. Moreover, Azerbaijan has purportedly identified hundreds of other ethnic Armenians that it plans to arrest. There is, as the court is well aware, a long-standing and well-documented history of mistreatment by Azerbaijan of ethnic Armenian detainees and prisoners of war. Azerbaijan must thus be ordered to refrain from any action that targets these individuals simply based on their role as democratically elected representatives or as persons charged with the maintenance of security, and further must be ordered to respect and protect their fundamental human rights. The 8th measure we request is that Azerbaijan shall not alter or destroy any monument commemorating the 2015 Armenian genocide or any other monument or Armenian cultural artifact or site present in Nagorno-Karabakh. Despite the court's December 2021 order, Azerbaijan has continued to vandalize and destroy Armenian cultural sites in areas where Azerbaijan took control after the 2020 war. There is every reason to believe that Azerbaijan will proceed in the same way now that it has taken control of the entirety of Nagorno-Karabakh. In fact, as you heard from Mr. Martin, just 2 weeks ago, Azerbaijani military forces opened fire on the 13th century Chagatar monastery and dismantled a large Armenian cross overlooking Stepanakert. Of particular concern, as Armenia noted in its memorial, Azerbaijan does not consider any of the hundreds of ethnic Armenian cultural sites in Nagorno-Karabakh to be Armenian. As such, there is nothing suggesting that Azerbaijan will refrain from altering the character of these sites or from destroying them altogether. A court order in this regard is thus imperative to protect the remaining Armenian cultural artifacts and sites in Nagorno-Karabakh. The 9th measure that we request is that Azerbaijan give effect to and not destroy civil registers, identity documents, and property titles and registers established by the authorities of Nagorno-Karabakh. Azerbaijan has made no secret of its Great Return Plan, which seeks to resettle Azerbaijanis to the parts of Nagorno-Karabakh which is now controlled by Azerbaijan. This plan is already in motion, in the places that Azerbaijan took over after the 2020 war, and there is every reason to believe that Azerbaijan will now expand it to the whole region. In pursuing this goal of resettling Azerbaijanis, Azerbaijan must ensure that it does not prevent the return of ethnic Armenians who were forced to flee their homes and businesses. Yet this would occur if Azerbaijan destroys property records and civil registers, or, as Professor Darjan will discuss, if Azerbaijan supersedes such records through some new registration process. Armenia has detailed in its memorial the difficulties ethnic Armenians have experienced historically throughout Azerbaijan in having their property rights respected. And absent court action, these same difficulties will now unfold in Nagorno-Karabakh. As previously noted, I leave our presentation on the 10th measure that Armenia requests to Professor Darjan, but I wish to stress that all of the measures we seek, all of them, are necessary notwithstanding the court's prior orders in this case. Virtually all of the measures we now request have no express analog in the December 2021 order, such as the measures we request addressing the return of ethnic Armenians to Nagorno-Karabakh, or addressing the taking into custody of high-ranking civilian leaders during this past month. Our present request concerning the protection of cultural heritage does have an express analog in the 2021 order, given that that order required Azerbaijan to take all necessary measures to prevent and punish acts of vandalism and desecration affecting Armenian cultural heritage. Our eighth request today, admittedly, essentially asks the court to reaffirm its previous order. But this is a necessary step, given that Azerbaijan has resisted the 2021 order, claiming that it does not cover any alteration or reconstruction of Armenian cultural heritage sites. They said that in a letter to you. And for the avoidance of doubt, it is important to stress that in the requested measure we bring to you today, that Azerbaijan not alter or destroy any monument commemorating the 1915 Armenian genocide, this is critical given the presence of numerous such monuments in the areas now under Azerbaijani control. And this is all the more so critical given that Azerbaijan is one of the few countries that denies the Armenian genocide and that previously destroyed Armenian monuments commemorating the genocide when it had the opportunity to do so. The new circumstances and the irreversible nature of destroying cultural heritage makes it imperative that the court issue a provisional measure on this issue. Indeed, the new circumstances that have now unfolded make imperative all the measures we request so as to clearly target and reinforce Azerbaijan's CERD obligations in the context of the present crisis. The court has viewed the existence of new circumstances to warrant issuance of new or supplementary provisional measures, as you found when issuing further measures in this case to address Azerbaijan's conduct concerning the Lachin Corridor. The context in which Armenia comes before you today is dramatically different from that which existed at the time of the court's orders in 2021 and even earlier in this year. Moreover, if Azerbaijan is to be believed when it says that no harm will come to the ethnic Armenians of Nagorno-Karabakh, which this past month, some 100,000 of them have sadly and painfully demonstrated they do not believe. But if Azerbaijan truly intends them no harm, then Azerbaijan should have no concern with the court's issuance of these provisional measures. Rather, it is Azerbaijan's protestations as to such measures that vividly demonstrates why they are so desperately needed. Madam President, members of the court, my last point is that the court's issuance of these measures would not require the court to resolve any facts that would be prejudicial to decisions on jurisdiction or on the merits in this case. After you hear from Azerbaijan's counsel this afternoon, with references, no doubt, to the many exhibits they produced just 2 days ago, you may think that there are disputed facts that should not be resolved at this stage in the proceeding. Yet the core facts relevant to the measures that we request are not in dispute. More than 100,000 ethnic Armenians have fled Nagorno-Karabakh in fear. They are not on vacation, and there can be no dispute that they would like to be able to return to their homes and to live their lives peacefully in a land that their ancestors have indigenously occupied for millennia, if their rights and security can be assured. Armenia has demonstrated that they fled because they fear for their lives, they fear for their homes, and they fear being taken into custody. While Azerbaijan no doubt will dispute the reasons we have advanced for Azerbaijan's military actions and will deny that its conduct constitutes ethnic cleansing, there can be no dispute that more than 100,000 ethnic Armenians are currently displaced, or that still others remain highly vulnerable, and that measures must therefore be put in place to ensure respect for their rights under the CERD. Given those undisputed facts, it matters not how Azerbaijan this afternoon justifies its actions. For today, what we are facing is a massive crisis of displaced persons and other tragedies. This is precisely the type of situation where the court must issue provisional measures so as to protect an ethnic group from any further denial of their CERD rights, pending the court's disposition of this case on the merits. Madam President, that concludes my presentation. If it pleases the court, Professor Darjan will now continue Armenia's presentation.
I thank Professor Murphy.